Welcome to today's webinar. Thank you for joining us. We're going to talk about the peptide opportunity today and how pharmacies can prepare without crossing legal lines. My name is Nicolette Matthey. I'm the pharmacist and founder and CEO of Atrium 24 and the Dae Lee CRM software. We talk with a lot of really smart people about really exciting things. And so without further ado, I'll introduce you to one of them. We have one of our legal friends on the webinar with you to have this conversation today, Dae. We'll let Dae introduce himself.
Thanks, Nicolette, and thanks for joining me today, everyone. My name is Dae Lee. I'm a pharmacist attorney, shareholder at Buchanan Ingalls Rooney, and I'm a co-chair of our firm's PBM and pharmacy practice group. I represent a lot of independent pharmacies of all types, compounding, retail, mail order, specialty, as well as employers and plan sponsors, mainly in the insurance fields, but also cash industry is uh, specific to compounding pharmacies.
Awesome. Thank you so much for joining us today, Dae. And then we have your partner Lucas with us today, who we're really excited about. Lucas was with us at Atrium X, as was Dae. Lucas, you want to say hello?
Yeah, absolutely. Thank you, Nicolette. It's great to be here today. As Day mentioned, and as Nicolette mentioned, Day and I are partners here at Buchanan, and I'm the other co-chair of our PBM and pharmacy practice group. In that area of focus, we represent really pharmacies all throughout the country in a wide variety of settings, with definitely a heavy focus on representing independent pharmacies, especially in the compounding space, 503As as well as 503Bs. I would say there's a heavy focus on compliance at both the federal and state level. We definitely do a lot of work working with various regulators, state boards of pharmacy especially, as well as the various federal regulators, the FDA, so on and so forth. So really looking forward to today's discussion.
Yeah, thank you guys so much for joining us. We have a lot to talk about today. I'll just pop up the agenda here. But we just really wanted to have a conversation with you guys because, as you know, we just came off of Atrium X, which is our annual conference that we have here where we bring a lot of really smart, innovative, like-minded individuals together. And the thing that I really like about our group of pharmacy operators and owners and entrepreneurs that come together, they're very compliant. They do things the right way. They're very smart business people, and they really care about their patients. They care about their boards of pharmacy. They care about the FDA. So we all want to make sure that we're doing things the right way. So interestingly, when we all voted on topics at Atrium X about what we wanted to talk about, more than 2 times over, it was peptides. And there's so much going on, and that's such a buzzword. GLP is a peptide, insulin is a peptide, and there's some new peptides on the horizon. So from a legal perspective, what is the current status of peptides? And I'll go ahead and cue the agenda off here just so we can kind of converse informally. But right now, what's the current legal status of peptides for compounding pharmacies today?
Well, peptides are everywhere right now. I mean, if you talk to any pharmacy owner, operator, or any consultant, peptides have become one of the fastest growing revenue stream in the industry. Whether it be weight loss, anti-aging, or wellness, there's a lot of momentum. But the issue is the market has moved so much faster than the law, right? And there is definitely a gap. And you know, um, from attorney's point of view, that's where it's a gray area. And gray area, there's opportunities for growth, opportunities for revenue, a lot of revenue, but there's also opportunities for legal risk, right? If we first focus on GLP-1s right now, GLP-1s, semaglutide, tirzepatide, off of shortage list, okay? FDA has been sending warning letters to stakeholders, but mostly marketing places or marketing companies or even the suppliers of APIs. On the other hand, the brand manufacturers, Novo Nordisk, Eli Lilly, of course, they have been sending out a lot of cease and desist letters, and they have filed many, many lawsuits. But at the same time, that does not mean that if your company or if your pharmacy receives cease and desist or warning letter or even a lawsuit, that does not mean that that's the law. Okay, especially the private lawsuits. And there are several instances where the manufacturer lawsuit got dismissed in favor of the defendant. Okay, now putting that aside, if we look into the category 1 as well as category 2 peptide, that's more of a clear cut rather than gray area. Okay, in the legal realm. Category 2, significant health risk. So you're not allowed to compound those ingredients. Category 1, you can or you may until FDA makes a final decision whether to place any of those products currently listed in Category 1 in a bulk compounding list or not. That's the overall stance in the peptide world, GLP-1 versus non-GLP-1s.
Now that bulks list in the category 1, category 2, that's been kind of not clearly defined and floating out there a bit for what, like a decade or something, right? In the bulks list. And it's not, I don't think it is as cut and dry as perhaps was intended when it first came out. Things don't seem to move quickly in practice from the lists, and things don't seem to be clear. There's not a lot of evidence behind some of these therapies, and the progression of the evidence is not funded by pharma. So there's kind of no, like, why would someone fund research on BPC-157? Because pharma's not going to make a bunch of money off of it. So it's kind of like a weird cycle that we're stuck in where we don't have much clarity.
Right, exactly. And if we focus on like the Federal Food, Drug, and Cosmetic Act, especially the 503A section, which governs the 503A compounding pharmacies. 503As, they can only compound using the bulk drug substance, right? That meet the certain criteria. And these criteria are, FDA approved drug, listed on have a USP or a national formulated monograph, or included in the applicable bulk substance list. So 503As, I think, in a way, I mean, the bulk list it's a live thing in and of itself. It changes and it can change down the road. But for 503As, FDA has been pretty clear as to what 503A compounding pharmacies can use in their compounded products. Now, if we move into the enforcement, it becomes very murky and complicated. And, of course, 503A compounding pharmacies are not truly under the jurisdiction of the FDA. They're governed by the State Board of Pharmacy. And 503B outsourcing facilities, on the other hand, is under the jurisdiction of FDA and not State Board of Pharmacy. And, my partner Lucas is really, I view him as the authority in the Board of Pharmacy realm and space throughout the country. So I will defer to him as to recent, enforcement, on 503A compounding pharmacies by different state boards.
Thanks, Dae. And I think you, as always, you said it really, really well, which is when you said earlier that the marketplace has moved faster than the law. Now, that's not uncommon because you'll often hear phrases like the wheels of justice move slowly, so on and so forth. So that's not uncommon. But here, I do really think there's something unique where we're seeing in the marketplace, the demand for peptides is just sky high. There's a demand by patients who I think really want to have independence and direct control over their healthcare and medical decisions, and also their overall wellness and well-being. And they see peptides as something they want to be able to utilize in their own health and wellness plans. At the same time, the law seems to suggest sorry, you can't do that right now. They're putting almost like a strict limitation on it. But to the point you made about the distinctions between FDA and its direct oversight of 503As versus 503Bs, where and then how state boards of pharmacy seem to definitely be much more focused on jurisdiction over 503As. Most state boards of pharmacy, in some way, shape, or form, adopt, basically by very simple rule or regulation, FDA guidelines. So that is why we will typically encourage 503As and other pharmacies to very closely monitor FDA rules and regulations. It's because your home state board of pharmacy and or any other states where you operate as a non-resident has almost certainly adopted the FDA rules and regulations. Now, some states add certain caveats to that. They might enhance them or add some details. One example of that is California. California recently adopted some more explicit language trying to articulate the standards by which they're going to measure whether a compounding pharmacy is preparing a compounded product in a manner that constitutes essentially a copy or not essentially a copy. So that's just one example. Now, one of the things that I say here when we talk about risk exposure, especially as it relates to compliance with your state board of pharmacy, is that in many ways, you're almost kind of managing an independent personality. So we see many states, even though they may adopt FDA rules and regulations, seem to be a little more open and receptive to the notion of peptides and compounding such products. So there is certainly anecdotal evidence throughout the country in certain locations that would suggest that certain boards of pharmacy are not going to take a strict approach to the compounding of peptides.
Right. What that makes me think of, and again, so I'm a pharmacist, not legal advice here. Don't take anything that I say to the courts and say Nicolette told me so. But just conversationally, when I think of a spectrum, I think of California and how California and their board of pharmacy said that they're going to start talking about like clinical appropriateness and kind of broaching that line. And then I think of Texas on one of the other sides of the spectrum, where I know even just in our practice and working with pharmacies, we're seeing there's marketing materials out in Texas. There's pharmacies that are marketing and compounding and selling retatrutide, which is not FDA approved yet. They're doing the BPC-157. They're doing Wolverine stacks. They're dispensing all these things out of pharmacies. And so, of course, we recommend don't do that. Your state board is likely going to have an issue with that. The FDA is like going to have an issue with that. But that comes into, and this came up at HRMX as well. There's very strong words, illegal. So there were some folks that got, concerned that the term illegal was being thrown around because there's legal, illegal, non-compliant, gray area. So what do pharmacies have to look at and to worry about about legality? Like, what's the correct way for pharmacies to think about the difference between those words, illegal, non-compliant, or even just not eligible for compounding?
Yeah, so let me take that first and then turn it over to Lucas. Just to cover the category 1 and 2 again. Category 1 substances are those that have been nominated for inclusion on the 503A bulk list, right? And then that are currently under review by the FDA. And FDA's view on those that are listed in category 1 is that you may compound, and FDA may not exercise the enforcement authority on those products, right? Those substances. Category 2 are very different. These are that FDA has identified as raising safety concerns or lacking sufficient evidence to support their use. So from a legal standpoint, these should not be compounded. And FDA has said that, clearly that category 2 should not be used in compounded products. Okay. Now that's the legal standpoint. And then, I'll give you an analogy, and I don't know if this will, make sense to all of us or everyone joining today. Is illegal not to wear a seatbelt when you are driving a motor vehicle. Okay. Now, are everybody's following the law that they have to wear a seatbelt while driving or while driving a motor vehicle? The answer is no. Um, who's gonna enforce that? It's the local police officer, right? In this realm, let's say, pharmacies, compounding pharmacies who dispense compounded products which have include category 2, is that legal? The answer is no. Who is going to enforce that? Board of Pharmacy have all board of pharmacies react the same way or enforce the same way or put a lot of the same level of enforcement effort? Answer is no. It's different. Every state is different. California is different than New York. Maine is different than Texas or Florida. So is for pharmacies is they have to really, and I said this before at Atrium X conference. At the end of the day, you seek legal counsel to know what is legal or not within the realm of legality. Okay. But as a business owner, everybody has to make their own decision as to these are the risks that are, told by my own attorneys. And these are the level of risk is I can accept it or I cannot accept it. If I can accept it, you're making a business decision. At that point, it becomes a business decision, whether you're going to make X dollar amount versus not.
Yeah, that makes sense. And that's what I suppose some of the pharmacies out there that are dispensing these things now, that's the risk they're taking. They're saying, I'm going to go ahead and dispense these things. I'm going to source these things. I'm going to, just do that in my pharmacy and I'll deal with the board when it comes down. Most pharmacies don't operate that way. Because that's pretty blatant, I think. So most pharmacies don't operate that way, and we don't advocate for our pharmacies to
Correct.
do that. So today, we're advising our pharmacies that they cannot compound with BPC-157, that they cannot compound retatrutide, and we're waiting for things to change, and we're preparing. We're preparing which prescribers we're going to go talk to, which marketing materials we're going to use, where we're going to source the BPC-157 from, because I think that's going to be the first one. It's all speculation, but I think that's going to be the first one to move from a category 2 to a category 1. And then we'll be able to dispense that from our pharmacies. But when we're talking about category 2 to category 1, do we know, there's a couple comments coming in the chat. Do we know what led the FDA to move things from category 1 to category 2 in 2023 is what they're saying in the chat?
No, it's multiple factors, but ultimately FDA made a decision after reviewing, the data or clinical studies, so-called what's out there, and they made a decision to move certain products from Cat 2 into Cat 1, or sometimes, it's vice versa, or sometimes just products don't disappear from from either list.
Mhm.
And I also think we have to factor in certain market forces. I just think we, be a little naive to not think that that factors in. I mean, as a more recent example, I think a lot of people felt decisions to move semaglutide and tirzepatide from the shortage list to a position where there's no longer a shortage felt premature because there were still a lot of people out there that were saying, well, show me there is not a shortage, because a lot of people were struggling to find the commercially available products.
Right. And just something that strikes me too with the GLPs is, there's the market shrank a bit from the 503Bs that were compounding GLPs when the shortage ended. But there's still a handful of 503Bs out there that are making semaglutide and tirzepatide. whether it's different strengths than commercially available, whether it's with an additive like a B6. Um, it's not so like I think like you said, Dae, that's I don't want to say the wrong word because it's not even just in my interpretation as a pharmacist, it's not even a gray area. It's just not been clearly defined what is allowed, what is not allowed, what constitutes patient specific. So we know from our pharmacies, get medical necessity written out by your prescriber, why the patient can't have the commercially available strengths, have all that documentation, make sure the 503B is properly licensed and all this. But what's interesting to me is the FDA is still actively going out and inspecting these. I know the FDA because I've read the public inspection reports. I know the FDA has inspected some of these 503Bs after the shortage while they're making GLPs. And I'm waiting to see if there's any guidance that's come out or if there's any action that's come out. And I'm not seeing anything.
Yeah, it's just and that makes it, murkier, grayer, I guess, if that's the right word, for all the stakeholders. And, Lucas mentioned about market forces or, factors that affect the markets. The branded products, the manufacturers, they created direct to consumer model. They created their own channel of supply channel to drum up the volume of the prescriptions to their branded products. They also try to do so through manufacturer sponsored coupons, right? And they also cut deals with the current administration, or more appropriate way is they're participating in Trump RX, for for folks who don't have insurance, and then they voluntarily lower their prices, right? Um, However, I still do think there exists a large number of patients who just cannot tolerate the branded products, clinically or even financially. You know, I've said this many times at different venues or places. Compounding has been with the pharmacist since the birth of pharmacy. You cannot, nobody can control that. Nobody can say, oh, you can't compound. Everybody knows that. Even the manufacturers know that. That's why Lilly and Novo are trying different tactics, putting on lawsuits, right? Putting out lawsuits, connecting with the FDA, and then petitioning, to submitting petition to the FDA, demanding that, semaglutide and tirzepatide be listed in the difficult to compound list. Or, I believe Lilly more recently issued a letter to patients and providers warning that, there's a serious safety risk tied to compounded versions of tirzepatide, particularly when mixed with vitamin B12. It's on their website. I just checked them out before joining this webinar. But at the same time, FDA found at Eli Lilly facilities manufacturing deficiencies at the
Yeah.
same time. I mean, it's double standard all the way.
Right. Right. And there's so many questions as to how did Lilly procure those samples of the compounded tirzepatide with the B12? And it's really self-serving for them to put that out there. But
Right. Of course, it's completely self-serving. I don't think it does any justice to the patient who cannot tolerate branded products. Their motive is, unfortunately, from my point of view, is obviously 100% financially motivated to deploy all these different tactics without considering the patient population who can benefit, or maybe only benefit from compounded products.
there was a question too. So research grade chemicals and research not for human use, not for human consumption, research only API. Um, there was even Peptide Sciences, I think, was one of the big websites. And during Atrium X, even, the attendees were all sending me, look, Peptide Sciences voluntarily ceased operations and the market's actually shifting. What's happening? What's going on? So what do our pharmacists need to know about where they should be sourcing these things? And that could be a whole webinar on itself. But you have
Yeah.
you have patients coming in and patients saying that, oh, I'm buying research use only peptides, or where does that leave the pharmacies? And a part where we're running up against right now is as we're gearing up to, let's say the switch is flipped and now all of us can compound BPC 157. Where do we buy it from? How do we make sure that we're in compliance? So is there any kind of guidance there and legal risks for pharmacies participating in that kind of research grade market? I know there was the green list and that kind of came out and was a thing on APIs, but then that's been quieter than I expected because it's still a bit hidden or obscured who's on that green list. It's like, do we have anybody in charge over there that's that's organized? Because it's driving me nuts.
I mean, yeah, I mean, Lucas can talk more about certificate of analysis, but like the other day, I was just curious, and I Googled peptide. Bunch of marketplaces. There's no vetting process that goes in. And
Yeah.
then I click through terms of use, privacy notice in those websites, trying to make it seem like the marketplaces have no legal liability or no, obligation to verify the source of those products that they're selling. And it's so easy to buy. You just maybe like fewer than 5 clicks, I could buy BPC. I could buy, whatever that they're selling. Sourcing has been a hot issue, and FDA is really looking into it, right, Lucas?
Yeah, absolutely. I think going back to like answering the question of who you buy from, you want to make sure that you're only buying from registered distributors that are registered and authorized to do business in the United States. You want to make sure that you always have very solid, and I can't emphasize this enough, easy to obtain documentation, including your COA, your certificate of analysis. I can't tell you how many times that we run into situations where people have technically done everything right, but then all of a sudden an inspector shows up unannounced. And yes, most inspections are unannounced. And then all of a sudden they're like, hey, we have our COAs, but I just can't find them at the moment because they've been misplaced. Now, I've seen legitimate situations where they just caught them on the wrong day. But you want to have these things readily available so that if an inspector, whether it be from the Board of Pharmacy or the FDA, shows up, they're readily retrievable. Um, the other thing I want to mention too is on this notion of who you buy from and making sure they're registered distributors. When we talk about the situations where there's gray area, and so because there's gray, it usually means there's a lack of clarity regarding legality or illegality, compliance, non-compliance. So that may be a situation where someone is more comfortable making a business decision to take on a little more risk than they might otherwise be comfortable doing. I think one of the trends that Dae and I have seen is that where the FDA and other regulators have the most comfort taking enforcement action is actually going back to more foundational principles like marketing and advertising practices or purchasing from people who you just clearly had no business buying from. Like you didn't have your COA. These people aren't registered in the United States. What are you doing here? And so that's one of the most basic risk mitigation practices that pharmacies can adopt is make sure you're doing everything else that there is clarity on and that's well established very well and by the book so that if you are going to take on some additional risk that you don't get yourself, that practice doesn't get detected because other things like really non-compliant marketing practices were just easy to observe and enforce on.
And Board of Pharmacy enforcement is real, and it can result in very devastating impact upon the pharmacy, but also the pharmacist themselves. And especially when a board issues a disciplinary action on the pharmacy or pharmacist, and then let's say the pharmacy has multi-state license, the other state boards that the pharmacy has license, out-of-state licenses, they can just do a copycat action. And, there's many cases that Lucas and I handled together where, the pharmacy made a mistake and pharmacy didn't challenge the board's disciplinary action. Pharmacy didn't even know they had the right to have counsel and then just accepted the disciplinary action without knowing the aftermath. The aftermath being the other boards of pharmacy just, joining the bandwagon and then issuing the same copycat disciplinary action. And the other aftermath is obviously insurance companies. Some of you who joined today may have, joint model. Joint model being one side of your business is cash business. The other side of your business is insurance business. Insurance being pharmacy benefit managers, PBMs. And when you have a disciplinary action or any other adverse action against the pharmacy or the pharmacist, it's a reportable event to those PBMs, meaning under the major or top 3 PBM provider manual, it specifically says the pharmacy, the network provider, must report to the PBM of any adverse event. And adverse event includes a lot of things, including disciplinary action. And if you don't report within the set deadline, usually between 5 to 10 business days, that can be a triggering event for network termination. And if you don't, and then let's say they find out after looking at the board website, because all these disciplinary actions are searchable and is public knowledge, then PBMs will likely terminate the contract. And of course, PBM will issue a notice of termination, whether it be the termination being taken effect immediately, 30, 60, or 90 days out. You have an option, you have the right to challenge it. But before you even get there, you could preemptively remove or mitigate the risk by being in compliance with different laws and regulations, but also pushing back on any citations or this attempt for disciplinary actions issued by different boards of pharmacy.
I think that's a great point, and it's really fresh for me because we had our board inspector in my pharmacy yesterday in Florida, surprise inspection. They were just here in June or so, 8, 9 months ago, and they were back. Since I talk to you guys so much, and since I just really overanalyze everything and watch everything on the legal front, I was tempted just to, as he questioned things or as he was interpreting things, and I asked him, I'm like, well, where does it say that in the statute? In Florida, Chapter 465, where does it say that? Or how did you come to that conclusion? And I was tempted to just not say anything to him and say, talk to our lawyer. So it's such a weird, you want to be helpful, like as a pharmacist, because you're doing everything the right way and you're doing the best you can, documenting everything. And Lucas, you're exactly right. It's usually the small things. Like I couldn't find a certain SOP for him immediately, and he wanted everything printed. I have a lot of things electronic, and he was a little thrown by that. So I was pulling up the documents and things. So just little things like that. But I'm trying to be helpful, and then I'm telling myself, Nicolette, you're talking too much. This is a legal interaction here. So what is that point? Like where should pharmacies reach out to you guys when they're dealing with their state board? At what point? Surprise inspection? Should we talk a bunch? Should we not talk at all? We also don't want to make them mad. It's kind of a weird position for pharmacists to be in.
Well, Nicola, you just described the quintessential Board of Pharmacy experience. And it sounds to me like you struck the perfect balance because I am constantly encouraging clients to strike a collaborative, cooperative tone, no matter how tempting it is to get adversarial. And when people ask me where my recommendations come from on this, it comes from working in board of pharmacy work for coming up on 15 years and working closely with current and former board members, including presidents of state boards of pharmacy. And they have told me, Lucas, anytime you get adversarial with a board of pharmacy representative, whether it's an inspector, an investigator, or a board of pharmacy member that sits on the actual board, it's not going to help you. Now, and more importantly, it could really hurt you. So I always say we're doing a dance here. It's a little bit of a dance. But I also want to be clear, there is a time to definitely invoke your right to legal counsel. Not in none of this is criminal. Now, to be clear,
Right.
in some extreme cases, really egregious conduct on the civil side or the administrative side could lead to criminal consequences. But that's a whole different webinar topic. But you should never feel like you can't have your attorney involved in these proceedings. And I assure you, Dae and I and our team here at Buchanan, we deal with board of pharmacy representatives all the time. So we also strike a real balance. You know, we don't immediately go off the handle. We don't, because we understand how important it is to maintain that collaborative spirit. So I think the situation is you want to be cooperative and collaborative, like you said, Nicolette. If you ever feel like you're starting to get into a situation where the inspector or investigator is going down a line where you're just starting to feel like something seems off, it feels like they might have it out for me, it seems like they're really trying to walk me into a corner and get me to admit to something or something like that, that's when I recommend getting a lawyer involved. And a way to do that without, I think throwing down a gauntlet, so to speak, is to just say, hey, I take this really seriously. If you don't mind, I'd really like to call my attorney and have them on the phone while we talk through this. I'm 100% committed to working with you, but I just feel like this stuff's really important. You're asking me some tough questions, and you can, call us, put us on speaker, and then we can listen in as things go forward. We've done that many, many times. And honestly, the most simple reason sometimes is so you just have a second set of ears or potentially eyes. And obviously, if something is more formal and planned, we might be there in person.
Right. And, boards, every board is different. Every inspector or investigator is different. Some are more aggressive, some are more laid back. It's like a form of art. And then a lot of times boards tend to, like a better word, they like to flex their muscle, right? And we've had an instance more recently, Lucas and I represent a pharmacy who had, like you, Nicolette, unannounced surprise inspection. And that inspector was very aggressive. The inspector at one point said that he was a cop, in the past, but he made it sound like he is presently a cop and, to try to intimidate our client. And that type of tactics are common in the during the board of pharmacy inspections. I don't know. It's hard to understand why they have to conduct their business like that, but I guess that helps with their job. And another analogy is same thing as the DEA inspection. They come in unannounced. They try to find all these potential violations. And sometimes they ask you to surrender the DEA permit right there, right then. And we got on the phone on many instances, and we speak with the investigator, and they tend to many times, if not all times, take a step back and then let us have a more private conversation with our clients, and then respond to their request for surrender at a later date after having a chance to review and evaluate the situation.
And I would just mention too, the anecdote that Dae shared, those are very real experiences. I would say that one was so real that it took us a lot of time to figure out that we actually weren't talking to a cop. We were actually led to believe that initially there was like a police officer there. So we finally were like, okay, wait a minute. So you're not. I say all that though, because having dealt with Board of Pharmacy inspectors and investigators all over the country and pretty much all 50 states at this point, there's a lot of inspectors out here that don't adhere to that type of approach. And like Dae said, I can't really say why they choose to utilize that type of a tactic. They may find that that's been effective for them or some other reason. But at the same time, a lot of inspectors we have found have conducted themselves as the utmost professionals. But the one thing that I think is important to keep in mind so that you can, I think it's it's helpful if you understand the perspective that a Board of Pharmacy inspector is coming from. They do have bosses. They report to someone. They work for the state. So, and if you go to any Board of Pharmacy website and you look at their mission is going to say, we are here to protect the residents and patients of this state and to protect their health and well-being. And at the end of the day, they take that seriously. And so when they come in and conduct a comprehensive inspection, you need to understand that they're not just going to give you a free pass on potential violations. Now, you might establish a really good rapport or a relationship. I've worked with pharmacies who've had the same inspector for 20 years, never had an issue. It's because they got along really well, mutual respect, and said, look, technically I could write you up for this, but it's not a huge deal. I know you're trying to do everything right. Fix this. I'll be back in a week. Make sure it's not here when I come back. That happens. And I think depending on the circumstances, that shows a really good mutual respect and relationship. All of a sudden that inspector retires and now a new person's been assigned that territory and they come in and they're sitting there with a 3-page write-up and they're like, this has never happened to me before. So just keep in mind those like shifting tides, so to speak, but also the perspective the board inspectors coming at it from.
That's exactly right. I think that's what happened with us. We didn't get written up for anything, but I've been working in pharmacy in this town for 26 years, and we had one inspector for most of that whole time. And he was great. And that was the thing. It was very collaborative. That way we felt comfortable with him. If something came up, we would give him a call and we would ask him a question, or we would let him know about, a pill mill doctor's office back in the day, or whatever it was. We would collaborate, like you said. So it's strange to potentially have an adversarial approach on a new inspector. And it's like, what's happening here? So you do want to be collaborative. I'm thankful that you gave us that approach, because it does feel a bit uncomfortable for me to then say, well, I'm going to call my lawyer. I don't like what you're telling me. So just to tell them, like, yes, we take this very seriously. Compliance is serious to us. Do you mind if I give my attorney a call? Because I want to make sure we get this right. I want to make sure that we're giving you everything that you need. So someone asked too, Sheila asked, so how do you, well, there's a lot of comments in there. But how do you get that relationship with you guys, like as pharmacy owners? How do we have an attorney or a legal counsel working with our business in these situations? How do we prepare ourselves to be ready to call you guys in case we have an unannounced situation where we need you?
Well, the short answer is to engage us. And that doesn't mean paying a bunch of money or anything like that, but the key distinction there is you don't want to be trying to retain legal counsel in the midst of an unannounced inspection or investigation. So I always say the best time to retain and get to know your attorneys and legal counsel is when everything's great, when the inspectors aren't there. That way, we're essentially on call. And, I can tell you, Dae and I are, we share our cell phone numbers. We will often get phone calls that we weren't expecting or text messages that says, are you available? Or please call me now. And we do that. And if you say, hey, we just got an unannounced inspection and I'm really nervous, this is my first one, so on and so forth, we will do our very best to walk you through it. And we have a team of attorneys, behind us as well. We can't be in two places at once. So we always have a qualified attorney that's available to help walk you through those things. So that's how we handle the unannounced surprise inspection.
Yeah.
For anything that's planned in advance, we can be there in person. I would not suggest that we need to be at every single inspection that occurs. What I would say though is if anything is part of a planned proceeding, especially if it's now taken on the term investigation as opposed to inspection, those are times where I do think being in person is helpful and beneficial. And Dae and I have done that many, many times.
Yeah. I
And
think
the
that's
other
helpful. I've popped your guys' contact information up here. Because Megan asked, what's your guys' retainer? I know inside of Dottie, Buchanan and Dae, and you guys are a part of the Atrium 24 GPO. So if any of our Dottie members, if you click in the GPO inside of Dottie, you can access these guys, and they have, you know, special rates and retainers and type things for our Dottie members. Because like Lucas said, it's not a ton of money. They're not going to charge unless you've changed your business model, you're not going to charge a huge upfront retainer just to have the pleasure of knowing you.
Right, right. And Lucas and I represent, as I said before, a lot of independent pharmacies. We feel like we're on the right. We know we're on the right side of the pendulum, right? We are, we always go against the Goliath, whether it be the PBMs or private companies or even regulatory agencies, including Board of Pharmacy. And sometimes, and not all of our clients do that, and we would like all of our clients to do this, which is the gap analysis. As Lucas said, the appropriate time to engage counsel is when everything's going well, right? Everything's going well, but there's going to be some gaps in your compliance. There's going to be some gaps in your operation that may have some impact down the road. So if you engage us, we could provide gap analysis, fill in the hole, and then make sure that you're in compliance, and then your case becomes defensible in the event there's any investigation or any scrutiny coming down the pipe. And the other thing is, and Lucas mentioned this many times before, make sure you have a copy of the provider agreements that you signed with PBMs, if you have PBM contracts. Is so often that our clients don't have a copy of the PBM agreements or provider agreement when we actually need it. Okay, and they can't. If they ask their PSAO or their PBM, it might be too late. So just have all those documents handy, save it in a database when things are going great.
Yeah. No, that's really smart. It's something that so as a software company owner, we have something called a data room. And I didn't really know what that was, and it sounded very high tech. It's not. It's just an organized way to keep all of your documents, all of your agreements, all of your tech stack details, all of your cybersecurity, all of that. And in the pharmacy, earmuffs, guys, but we would call it an oh shit binder, where, like if the inspector comes in, everybody on the team has to know where this binder is because the pick might not be there that day or the owner might not be there that day. So you grab that binder and you say, okay, everything's in here. And it's funny, that's kind of where inspectors expect to see it. And this guy yesterday, he was going all through my binder. He was taking papers out. He was doing all kinds of things. I was like, yikes. And I was thinking, man, is that binder updated? When was the last time I checked on that thing or looked at it? So that's great advice to almost do a pre-audit of yourselves and almost make sure either it's printed in your OSB binder or or it's in an organized like Google Drive or something electronically, and the whole team knows how to access all the things. So that's really important just to get ahead of it.
Nicolette, I'm vigorously shaking my head because I approve, I approve, I approve. This is what I tell everybody. Have both the binder and the readily retrievable digital form as well. It may sound a little old-fashioned. It may sound a little old school to actually have hard copies, but here's why I'm going to suggest that you do, even though in most instances the digital form is sufficient. Sometimes you have internet problems. Sometimes you have a power issue. Something comes up. I'm telling you, I have seen boards of pharmacy take disciplinary action based on an allegation that policies and procedures were not readily retrievable or available during the inspection, or they'll even take the position you didn't have them, and it was because of a computer issue. So have the hard copies. I recommend that you try to take the time to look at them and update them at least quarterly. I'm practical here. You can't do it weekly or monthly. In theory, if you could, that would be great. The other piece is the reason why I recommend that binder, the OSB, which I'm good with that term. If an inspector comes in and you immediately hand them a binder or set of binders that clearly identifies, policies and procedures, your compendia, anything that you're required to have, they're going to know they're working with someone who knows what they're doing, knows their stuff. You immediately send a message right out of the gate, and that can help set the tone of the inspection. You seem prepared, you seem like you know what you're doing, you take it very seriously, and that right out of the gate can really help to set the right tone. And perhaps I'm going to use the term de-escalate. I'm not suggesting that it's escalated to start, but it goes
Right.
a really long way.
Right. Yeah, I love that. Even though this may seem fundamental, as we are concerned about growing and evolving and innovating, we can't let any of the fundamentals slip. And just like you're seeing with the Lilly, lawsuits that are coming out, it's on marketing and it's on terminology and it's on things that it's not the big gotcha, like you can't do this thing, or they're not approaching that yet. They're kind of taking the easy wins, things that are black and white that the pharmacies, shouldn't be doing. So if we pull, because we're almost at time, and if we pull back to, if we think that on the peptide side that the BPC-157 I'll pick on, let's say tomorrow that it moved categories, right? That's kind of what we're waiting for. Let's say there was some announcement from the FDA. I know at Atrium and our Dottie members, we have all the marketing materials for BPC-157, the patient information sheets, the prescriber education sheets. Of course, being careful not to make any claims. We're stating clearly on the documents that no compounded products are FDA approved. And then we have the RX order forms. I know at least one of our 503Bs in the Atrium 24 GPO is ready to go with BPC-157. They have it in testing, stability, sterility, toxicity, endotoxin testing, all those kind of things. They're ready to go from what we understand. We have the GPO pricing all negotiated for our pharmacies to go to market. We have the recommended retail pricing ready for pharmacies to go to market. I do think that retail pricing will shift based on the gray market players getting out of the market, hopefully and potentially. But so all those things are in mind. We're looking at it from a sales and marketing and a go-to-market perspective. Legally, what do our pharmacies need to do if tomorrow BPC-157 moves from what, category 2 to category 1?
Yeah. Then, pharmacies need to see it from the FDA directly, not
Yeah.
from a podcast.
Yeah, right.
So if FDA officially moves substances from category 2 into category 1, pharmacy may be able to compound.
Okay. And then
And I think very practically, like you want to move quickly, but I think you also want to be smart about what you do. But it sounds like, Nicolette, you described a set of you kind of doing everything you can within the confines of the law to be as prepared as possible so that if there is that overnight shift, that you can move quickly. So I think we all believe that it is coming soon. We just don't know when. I will say, I think it's going to take a little longer than people expect, given the comments from the podcast that Dae just referenced, because that does, believe it or not, in some ways actually slow down the shift from category 2 to category 1, despite what was said there, because there's some behind the scenes legal things that have to be worked out when a statement like that is made. But at the same time, I think we all see it coming.
I'm excited about it. I think it's a great opportunity for pharmacy. I think it's great patient care. I think that these peptides should be dispensed from pharmacies, and even back when medical marijuana went from just cannabis and everything to medical marijuana, and they completely bypassed the pharmacy channel. I was really disappointed in that because we already have a system to regulate dispensing of medications to patients and safety and all that infrastructure, and it was completely bypassed. So I'm excited to get peptides through the proper channels and to let us do what we do best in dispensing and taking care of our patients. We just want to make sure we're doing it the right way. So if you guys want to, and I highly suggest that you reach out to Dae and Lucas, and make sure that you have those fundamentals in place at your pharmacy. Make sure that you have these guys' phone numbers should you get a surprise inspection. I do think the market's rapidly changing. And you could be like me and have a brand new inspector and all of a sudden a potential situation. So that was an interesting wake up call yesterday, but all went well with the 2-hour inspection, luckily. And if you want to hear anything more about what we have in Dottie as far as peptides, what we're looking at, how we are preparing for the go-to-market launch and compliance at the same time, we do have GLPs currently in our GPO, a lot of acronyms. There's a lot of complexity there, as we know, and a lot you have to do to stay in the confines of what we know to be compliance for right now. But if you want to scan that QR code or go to atrium24.io /contact, and then you fill out your contact information, we can show you what the marketing materials look like in Dottie, what the data analytics look like, who our GPO partners are. We can talk about pricing, state coverage, all that, because it's very specific, as Lucas said too, with your boards of pharmacy, what state you're in. And sometimes we'll get you guys throwing a question at us about the state board and how does the state feel about this. And that's usually when we'll refer you over to these guys because they have so much real-time evolving knowledge in what's going on in each state and in each state board and in the enforcement. So you want to make sure that you just want to be able to sleep well at night, knowing you're doing everything that you can to protect your business, your employees, your patients. So I think we are ready to rock and roll when all these peptides finally do come to us, as they should. That's what I'm excited about. Do you guys have anything that you wanted to touch on before we jump for today?
I know on my end,
Oh,
we covered a lot. So
yeah.
always happy to answer any questions because I know we only have so much time. So if anyone wants to reach out today or I via email, we're definitely happy to connect further.
Well, thank you guys so much for your time. I know you're really busy, and I swear I always say what a time to be alive, and I mean it every day. It just keeps getting more and more exciting, and there's so much opportunity for us to take great care of our patients. And our patients trust in us, and I love that they come to us as pharmacists to steer them in the right direction. Nobody wants to buy research grade chemicals from some Yahoo website. So I know I don't. So if we can help our patients and eliminate polypharmacy and keep everything in our brick and mortar locations where we actually know our patients by name and care about them, that's the best outcome for everybody. And our inspectors have to appreciate that too. We're all on the same team. So thank you guys so much for joining us today. We will get this just edited and put into Dottie. This will probably be one that we'll put on YouTube as well. And so we'll get you guys the link and so we can share out the recording. But as always, really appreciate you, Dae, Lucas, and hopefully we'll be talking again very soon about the actual FDA announcement for moving some of these peptides around.
Looking forward to that.
All right. Very
Thanks,
good.
Nicolette.
Thank you guys.
Thank
Have a
you.
great day, everyone.